Hello friends, hope you're doing fine. I welcome you for the second tutorial about open source software. Please don't forget to subscribe to my channel and don't forget also to invite other people, your friends, to come and also enjoy these tutorials. Today's topic is about legal aspects. This is going to take us through the brief introduction to the intellectual property, and this is part 1 of legal aspects. We shall also have part 2 after this one. So here we gonna look at the copyright, the trade secret, patents and utility models, and then registered trademarks and logos. What is intellectual property? We sometimes abbreviate it as IP. Now, intellectual property or IP, here we are referring to the creations of the mind, such as inventions, literary and artistic works, designs and symbols, the names and the images in commerce. So intellectual property is seen as a category of property that includes intangible creations of the human intellect. There are many types of intellectual property, and some countries recognize more than others. There are some, the most well-known types are copyrights, patents, trademarks, trade secrets, among others. So when we talk about intellectual property, that's what we mean. The products of the human mind, the fruits of the human creativity, and the innovation. We have what we call the intellectual property system, the IPS. The intellectual property system relates to rights and obligations as well as privileges and incentives, and all these are rooted from the creation and protection of intellectual property. Remember, we said the intellectual property refers to the creations of the mind. So here we are talking about a system that is put to ensure that the intellectual property is enforced. You may ask yourself, what is it that the intellectual property system is created for? What's its purpose? Now, the intellectual property system enables the people to earn recognition and financial benefit from what they invent or create. You know, when you create something, when you come up with something, if you are an innovator, you are creative, there is that need. It is good to be recognized, and not only for recognition but also to benefit from your invention financially. So the intellectual property system aims to foster a balanced environment in which creativity and innovation can flourish. Now, this is the intellectual property family tree. In this tree we have the IP, which is intellectual property. Then the IP, under it we can have several. We can have industrial property, copyright, protection for traditional knowledge, and under industrial property we have patents, designs and brands. Let's talk about the basics of patents. So in these images, these are some of the examples of patents. So when we talk about patents, you can look at those images, though I know you've seen some of these already. Now, let's first understand what an invention is. It's a product or a process that provides, in general, a new way of doing something or offers a new technical solution to a problem. That's what I mean by invention. That process, or it can be a product, that provides a new way of doing something. If you come up with a process or a new product or a process of doing something that is new, that's an invention. And in most cases, your invention has to offer a new technical solution to a problem. So after understanding what an invention is, now what about a patent? A patent is an exclusive right that allows to prevent or stop others from commercially exploiting the patented invention. So you put an exclusive right, a high-class right, and this right allows to prevent or to stop other people from exploiting your patented invention. So if you come up with something new, you ensure that you patent it so that other people cannot just copy your idea and use it to financially exploit you or commercially use it to exploit you. So this patent is granted by a state, or it can be granted by a regional office acting for several states. The patent may be applicable in the country or the region in which the patent has been filed and granted, and in accordance with the law of that country or region. So this patent is usually for a limited period of time, usually 20 years from the filing date of the application. Let's talk about the 3 principal requirements for inventions to be protected. In other words, we are talking about the conditions for patentability. One is novelty. Here we mean the new characteristic that's not known in the body of existing knowledge prior to it in its technical field. So novelty in simple terms means the originality, the newness, in other words, the innovation. So that is novelty. So for something, a product or a process or a service to be patented, it must have this principle of novelty, the originality, the newness, the innovation. And another principle, number 2, is called the inventive step or non-obviousness. What does this mean? Something that cannot be deduced by a person with average knowledge in its technical field. So any person with average knowledge who is not a professional cannot deduce that knowledge in a particular field. So that is inventiveness, the inventive step, or the something that is non-obvious. So that principle has to also, it has to be made for patentability to be done. Then the third one is industrial application or utility. The invention must be of practical use or capable of some kind of industrial application and disclosure of the invention. So if you want your product or process to be patented, your invention must be capable of providing some industrial application. Okay, now if these conditions are not met, a patent should not be granted. If this is discovered later, so if they discover later that these conditions are not met, the patents can even be revoked or they can be made invalid. Okay, now let's talk about utility models. Similar to patents, utility models protect new technical inventions, and these grant limited exclusive right to prevent others from commercially exploiting the protected inventions without the consent of the right holders. Now, if you want to obtain protection, you must first file an application, and then the utility model will be granted to you. These utility models are sometimes referred to as short-term patents or utility innovations all innovation patents. Now, it's not easy to define a utility model because it varies from one country to another. So in general terms, you can consider utility models as particularly suited for protecting the inventions, which inventions in particular that make small improvements and adaptations of existing products, all the inventions that have a short commercial life. So in most cases, these utility model systems are used by local inventors. So you can consider utility models as short patents. Okay. Now let's ask ourselves this question. What kind of protection does a utility model offer? The owner of the utility model obtains a high-class right, the exclusive right, to prevent or to stop others from commercially exploiting the utility model for a limited period of time, and often this takes 6 to 10 years from the filing date, from the date you file your application and you are granted your utility model. It takes usually 6 to 10 years. So the owner of the utility model is given a high-class right, and with that right you can prevent or you can stop other people from commercially exploiting your invention. So in other words, in general terms, the utility model protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without your consent, the owner of the utility model, without you knowing. It's impossible. So if it so happens, the owner has the right to sue the people who have violated the utility model. So that right is territorial, depending on a particular territory. That is, the right can be enforced only within the country in which a utility model is granted. Okay, so that's an example. This image shows an example of a utility model. So you can maybe come up with an improvement, an innovation in something, and then you request for a utility model to be applied on your innovation or invention, and then they file a utility model. You have the details there, so that any person who uses your newly created knowledge has to first seek permission from you, the owner of the utility model. But don't forget that we said the utility model only apply for a limited period of time, usually 6 to 10 years, and in a particular state or country or a territory. So a utility model in one state may not apply in other states or in other countries. Let's talk about the main differences between utility models and patents. Now, the requirements for acquiring utility models are less stringent than for patents. That's the first difference. The requirements, what conditions are set for you to obtain the utility model, are less stringent, meaning they are less strict, less inflexible, less harsh when you compare them for the conditions or for the requirements for enforcing the patents. Now, the requirement of novelty, we have talked about it for patents, and we said novelty means that the new characteristic not known in the body of existing knowledge in its field has to be generated. So you have to come up with something original, something new, your innovation, for a patent to be granted. That's a requirement, or that's a principle. So that has to be made for a patent to be granted. Whereas for some countries, the inventive step or the non-obviousness, we talked about that, and we said for a patent, the inventive step has to apply, meaning that a person with average knowledge in that particular technical field cannot deduce what you have come up with. So that step, together with the novelty, in some cases may be absent for a for a utility model. The novelty step, the novelty principle and the inventive step may be lower, or they may even be absent, both of them, in some countries, and still they grant you the utility model. So that's what we mean, that the requirements for acquiring the utility model are less strict as compared to those for acquiring the patents. So in practice, we are saying that protection for utility models is often sought for innovations of a rather incremental character which may not meet the patentability criteria. Okay, another difference, number 2, is that the term of protection for utility models is shorter than for patents, and this varies from country to country. We said already that from 6 to 10 or even up to 15 years, that's the period for the utility model, whereas the patent can go from 20 years and above. Now we are saying that in most countries, that's number 3, patent offices do not examine utility model applications as a substance prior to registration. What does this mean? Registration process for a utility model is often simpler and faster, taking sometimes even 6 months or less. So in most countries, we are saying the patent offices, if they want to apply a utility model, they do not examine the applications as a requirement for registration. So the registration process is often simpler and fast. Number 4, the fees for obtaining and maintaining utility models are cheaper. That's self-explanatory. And then number 5, we are saying in some countries, utility model protection can only be obtained for certain fields of technology, such as mechanical devices and apparatus, and only for products but not for processes. So as we are saying, some countries, there are only a few fields where the utility models can apply, and in some fields they do not. So such fields like in fields of technology, mechanical fields, and apparatus. And again, in some countries, the utility models can apply for only products and not for processes. Okay, now let's talk about the basics of trademarks and logos. You know, a trademark and a logo are two different things which at times can be used one in place of the other. They can be used interchangeably, but today we're gonna see the difference between the two. And these two are not new to us. So let's begin with a trademark. What's a trademark? Now, a trademark is a sign capable of being represented graphically, which is capable of distinguishing goods or services of one undertaking from those of other undertakings. In other words, a trademark is simply a symbol, a word, all words legally registered or established by use and representing a company or a product. A trademark is also a type of intellectual property, and it consists of recognizable sign, as I have said, a design, or even expression which identifies products or services of a particular source from those of others. Although trademarks used to identify services are usually called service marks. So if you have a trademark to identify services, we normally call them service marks. Okay, having understood what a trademark is, let's also understand what a trademark does. So what does a trademark do? the proprietor of a registered trademark has exclusive rights in the trademark which are infringed by use of the trademark in the given territory without his consent. The proprietor, here we are talking about the owner. So the owner of the registered trademark has exclusive high-class rights in the trademark, and if any other person uses that trademark without his consent in a given territory where that trademark applies, that means the person has infringed the trademark. Meaning, infringed means has trespassed or has intruded on or has invaded the trademark. Okay, so that's what we simply mean by a trademark. So most of us have already seen these. You see this R encircled, you normally see TM, sometimes still there is a circle, and then SM. So R with that circle simply means a registered trademark, and this means unregistered trademark, and this means unregistered service trademark. Okay, so these are some of the examples of trademarks. Remember, we said it can be a word, it can be a sign, it can be a design, a symbol, and so on. And this symbol will distinguish one company from the rest of others, most especially the competitors. So you are seeing those common trademarks. And here we have the common Google trademark. We are saying that trademarking this logo does not protect Google from a competitor from using the word Google in their business or product. Okay. If you want now to create a trademark for your company or your organization, where do you go to register it? So these are the three possible routes to trademark your registration. 1, the national registration. 2, regional system of registration. And 3, international filing. So this depends on what you want to achieve and the laws governing registrations in your country or state. Okay, we have seen a trademark. What about a logo? A logo is a symbol or other small design adopted by an organization to identify its products, uniform, vehicles, etc. So a logo is a symbol or any other small design an organization can adopt whose purpose is to identify its products, uniforms, vehicles, and many others from other companies. So these are some of the common logos that you're seeing there. Now let's see the difference between trademark and a logo. A trademark protects a slogan, a phrase, word, company name, the logo, or design that identifies a company and or its goods. So you're saying that a trademark protects even the logo itself. We have already said that a logo is a symbol or a design used by a company that may fall under the trademark protection laws. So a logo, in other words, is a subset of a trademark. Among the many things that the trademark is entitled to protect is the logo. So we are saying that many businesses choose to apply for trademark protection on their logos. When these trademarks are approved, that trademark will now restrict others from using that exact trademark or logo or any similar mark. So in order to qualify for legal protection, the trademark must be unique. You cannot come with a trademark or a logo that is already registered and you think you will legally qualify for the protection of what's already existing. Now we are saying that prior to filing an application, So before you sign the application for your logo or trademark, the designer or the business owner should conduct a thorough search of the existing trademark registration database. So you have to go and make some search and see if really your design or your word or your logo doesn't exist in the registration database. If you don't mind, if you don't find anything similar, then that means your trademark or logo should receive the approval. So, but it's best to know before you waste time and money filing an application that gets registered. So this is common sense. Before you waste your time and money, you file an application that is gonna be rejected. Why not make a thorough search and see if your design already exists? It's certainly worth protecting a creative and original design, but generally more important to trademark the words in a specific mark or design. So here we are trying to gauge if you have options. Would you choose to protect your creative or design or your words or specific mark? And we are saying that generally it's even more important to trademark the words in a specific mark or design than the mark or the design itself. So those words are very, very important to trademark them, because it's very easy to come up with other designs, other logos and so on to design, and you come up, because the human mind is so creative in terms of design and artistic things. But now to come up with specific words that other people haven't used is not something easy. So it's more important to trademark the words in a specific mark or the design. There are several registration categories for trademarks, and some are more flexible than others. So trademarking your words offers strong protection, and more trademark infringements are based on protected words, not designs. So most of the violations that happen, the violations or the breaches of the trademarks come from the words, not even the design. So that's why we are saying that it's more important to trademark your words than even the design. We are still continuing trademark versus logo. We are saying that one of the most commonly trademarked symbols is a company logo. Businesses use their logo on marketing and advertising pieces, like on clothes, uniforms, on vehicles, on their logos, on their brochures, their flyers, and so on. So without a trademark protection, your logo is at risk. Imagine if you have your company and it has gained popularity, it's all over everywhere, people have recognized your logo. Like when you look at the trademark for Benz, you just know that that is Benz, even if you don't see the word Benz on it. You just see the trademark for Toyota, you just know that is a Toyota car, even without seeing the word Toyota. So imagine you have such a huge company and now your logo is recognized everywhere, and somebody else trademarks it, registers it before you. So that is a risk for a business. That person may take your jobs, because now their person will be the rightful owner of your logo. So it doesn't make sense if you use your logo without first trademarking it. So my friends, ensure that you also, if you have your company and organization, you abide by that guidance. We are saying that anyone in a similar business can use something very similar without any restrictions. That is, if your logo is not trademarked. We are saying that the purpose of trademarking a logo is to avoid confusion among the customers. Okay, when trademarking laws went into effect, lawmakers wanted to make sure that a consumer could clearly identify what product or service came from what business. So that's the reason as to why the trademarking laws came in. They want to ensure, they want the customer to know clearly and to identify who owns a product, who owns a certain service, and where does that our product come from which business, where does the service come from. Without proper legal protection, any company could replace another's logos without legal risk, and this will lead to confusion for consumers about which product to buy. Okay. Now these are study questions. In your own free time, you can go and make research about them. The basics of trade secrets. Now let's talk about trade secrets. A trade secret is any piece or process of a company that's generally not known outside of the company. So here we are talking about the information that is secret. Only the people in the company know about it. So this trade secret gives the company an economic advantage over its competitors and is often a product of internal research and development. So this is the secret of a company, and in most cases these trade secrets are not still known by every company worker or employee, but rather it's known by the top managers, the top owners of the company are the ones who made their research, came up with something, and they are the only ones who know about it, and thus gives them the uniqueness, the competitive advantage over their competitors. So the trade secrets are defined differently based on jurisdiction, but they all have the following characteristics in common. 1. Each trade secret is not a public information. 2. Their secrecy provides an economic benefit to their holder. And 3. The secrecy is actively protected. Okay. These are the examples, some common examples of trade secrets. Some of them are tangible and some are intangible. For example, we have the Google Incorporation's search algorithm, and this exists as an intellectual property in code, and it's regularly updated to improve and protect its operations. So only the top people in Google know about this search algorithm. It is not something that they can share with others. Each search engine like Yahoo, Bing, and others use other search algorithms different from what Google uses. So this is their trade secret. You know that Google nowadays is among the most popular search engines. So they have an advantage that has to be protected. That's their trade secret. There is a formula for Coca-Cola. This formula, it is said that it's locked in a vault where there is high security. It is protected. So this is also an example of a trade secret that is a formula or a recipe. And since it has not been patented, because if this formula goes to the public and it is patented, still you cannot use it to produce something that is similar to it. But these people decided not to patent it, so they have never revealed it. They keep it locked in a vault. They know what they do to create the Coca-Cola. We have another example of the New York Times bestseller list. The process, this is an example of a trade secret which is a process. So the process that they go through to come up with this list is a secret to them, because in most cases, one of the factors that the books are showing on the list, or one of the factors that lead the book to appear on their list, is the overall sales that the book makes. But again, at times, this is not the only factor. The list is not merely considering the sales numbers, you may find a book with higher sales not appearing on the list. So the process, the criteria that they use to come up with this list is a secret to them. So that's their trade secret, and this is an example of a process trade secret. So still, this slide here tries to show you, using the pictures, some of the famous trade secrets. We have already talked about the formula for Coca-Cola. There's also the Big Mac special sauce, the WD-40 formula, and the KFC chicken recipe. All these are secrets, and they don't want to reveal them because they give them an edge over their competitors. In other words, the competitive advantage is gained through making their formulas or whatever the process or the recipe as a secret. They don't reveal them. Okay. Now let's talk about copyrights and copylefts. You know, the term copyright is not something new, and it's very common as compared to the copyleft. Now, a copyright is a legal right bestowed upon creators of original works to dictate how those works can or cannot be copied, modified, and distributed by others. So this copyright, first of all, it's a legal right bestowed. This means given or granted to the creators of the original works, and this dictate how their works can be copied, modified, or distributed, or how they can decide not to allow copying, modification, or distribution. So the copyright legal does that. If someone uses or distributes or modifies your original work in any way, which way is contrary to what you allow as the creator, that is termed as infringement. That is violation, that is breach of the copyright. And the creator, you the creator, you are entitled to seek legal action. So the main idea behind copyright is that the creators restrict what others can or cannot do with their works, and so they must grant the individual permission to do otherwise. So if you want somebody to redistribute your work, to modify it, to copy it, you have to grant that somebody the permission. So that's the role of the copyright. So you're seeing these images, you normally see the circle with the C inside. That means that's the most the popular symbol of the copyright. All rights reserved by that person who owns the copyright. On the other hand, the copyleft, still this a circle with the C, but the C that has been flipped, it is facing in the opposite direction. So that's the symbol for the copyleft. So it's like the opposite of this one, all wrongs reserved. Interesting. Okay. Now, the copyleft licenses exist within the legal structure of the copyrights. Despite what the name copyleft implies, it's not just about abolishing the copyrights, no. But rather, these licenses, the copyleft licenses, are a subset of the copyright licenses, and their goal is to restore the freedom to users. Remember, copyrights ban the freedom. In most cases, you're not allowed to copy, to modify, to distribute, but now the copyleft grant, they restore the freedom to the users. So the core concept the core concept of the copyleft is that the users should have the right to freely use, copy, modify, and even distribute works whichever way they want, with one crucial clause, however, that all the derivative works must offer the same freedom to the users. So the copyleft licenses can give you that liberty or that freedom to copy, modify, and distribute your work, but all the derivative works, all the work that is derived from what you've obtained, should also offer the same freedoms to the users. Now, the copyleft, if you wanted to define it, it is the practice of granting the right to freely distribute and modify the intellectual property with the requirement that the same rights be preserved in the derivative works created from that property. So I've already explained that. Note, the copyleft infringement or the copyleft violation breach is also possible, just like the copyright. Failing to abide by the rules of a given copyleft license. An example of a copyleft license is the general public license. So failing to abide by the rules of such a license is still grounds for legal action, just like for the copyright. So this can be evidenced by when the Software Freedom Law Center won a lawsuit in 2010. You can read about that lawsuit in 2010 that was won by the Software Freedom Law Center about the copyleft. You can Google and get to know more about it. So that's a copyleft. We are saying here that copyleft is more than just permission. A copyleft license isn't the same thing as permissive license. In our next presentation, we shall talk about the types of licenses and we shall get to know more about permissive license. But this permissive license grants users the freedom to do anything they want. A copyleft license isn't the same as that, but rather copyleft licenses still impose some demands. The most notable aspect of copyleft licenses is the way they require users to distribute derivative works under the license that offers the same rights as the original work. So one of the the notable aspect of copyleft licenses is that when you get a service or a product under that copyleft license, you must also apply the same rights to the works derived from that product. We have an example here. Suppose you are a photographer and you release a photo under a certain copyleft so that you give rights for every person to use it as he or she wants. Now that user, if that user is within your rights of the copyleft, and the user can download that photo and the user is free to modify it in whichever way the user wants and can even distribute it to whoever he or she wants, that user has also to permit anyone else to modify and distribute your work still in whichever way they want. So that's an example of how a copyleft license is applied. That is what we call a share-alite clause. So that's why we are saying that the copyleft is different from the permissive license or even the public domain. So in the realm of software, it is why the BSD and the MIT licenses don't count as copyleft licenses because they do not meet these conditions for a copyleft license. We shall talk more about the BSD and MIT in the next tutorial. Now, public domain. We are saying that copyleft isn't the same as public domain. Public domain simply means that nobody owns rights to a particular work and nobody is free to do whatever they want with it. Copyleft is not that. You can take a public domain image, modify it, and then sell it under your own restrictive license. For example, you download any image, that is if it is free of charge under the public domain. When you download it and modify it, you can even sell it, and you can sell it under your own licenses that are restrictive in nature, not in the original public domain license. So public domain allows that. You can take MIT licensed source code, for example, modify it and release it under even a stricter license, but the copyleft doesn't allow that. For a copyleft, still what you have modified, your derivative work, has to abide by the same copyleft freedoms or the same copyleft license restrictions or grants under it. Now, copyleft doesn't just allow freedom, it requires freedom. I love that. Copyleft doesn't just allow freedom, but rather it still requires the freedom. So such licenses ensure that copyleft freedoms remain even in derivative works. We are also saying that copyleft isn't always free. Note that copyleft isn't always free. To reiterate, a copyleft license is defined by two main aspects. So I've already talked about them. If these two are there, then that is a copyleft. One, the freedom for users to modify and distribute derivative works, and two, the share-alike clause that maintains freedom in derivative works. So there is nothing that requires the copyleft works to be made freely available at no price, as long as these two main aspects are catered for. Nothing requires you to release your work and under the copyleft license free of charge. You can sell it but maintain these two aspects. So in other words, you might not be able to acquire certain copyleft work without first paying for it. So you can pay for something, for some work licensed under copyleft, but still, if you modify and if you modify that work however much you paid for it in the first case, you must still follow these two aspects in your work that is modified in your derivative works. And you are saying, but once you pay for it, you are free to modify and distribute as long as you maintain the same copyleft freedoms in the derived work. So we have an example of the Red Hat Enterprise Linux. This Linux kernel is licensed under the General Public License, that's GPL, which is also a copyleft license. Now, the Red Hat Enterprise Linux, RHEL, is a commercial operating system, meaning you don't get it free of charge, but rather you have to buy it, and it's built on the modified Linux kernel. Now, the desktop version of RHEL, that is the Red Hat Enterprise Linux, its desktop version is sold for around $49, but to abide by the general public license, the Red Hat Enterprise Linux source code is included in the purchase. Okay, so that's a good example of a copyleft. My friends, I thank you again for watching, for learning, for inviting your friends. Please invite more friends, and don't forget to subscribe to my channel so that you might get notifications about the new uploaded videos. We meet again in the next tutorial. God bless you, and don't forget that Jesus is the way.